a data policies specialist at Inrae. Inrae is a French public research organization which is dedicated to research in the fields of agriculture, environment, and food. We are based in Paris, in France. And I have the pleasure of speaking to you this morning on a fascinating subject concerning data. And before going further on this topic, I would like to thank you for your presence. And I would also like to thank the UNITA network for its invitation. So let's start. You have probably noticed as researchers that you are starting or developing your scientific career in a context of high intensity data regulation, and especially European regulation. This means, among other things, that the regulation you are currently experiencing is also experienced by your colleagues in all other European countries, and maybe by other non-European colleagues through the European or international partnerships you may participate in. You probably wonder why this happens now, who is concerned by this regulation, and how this will impact your daily activities. I will try to help you understand the basic principles around data regulation. This will be the first two parts. Then we will have a look to how all this impacts science, and this will be the third part. Then we will conclude by your questions, if you have any. And anyway, I will propose a question and answer part at the end of my presentation.
Sorry,
yes,
Stephanie, we didn't see the presentation.
So what do you see actually? Do you see it now?
Yeah, perfect. Okay.
Okay.
Thank you.
Thank you for the notice. So let me kindly remind you that this session does not aim to be a comprehensive legal course. It is meant to be an opening to the subject, an opening to discussion if you want. And it's a very basic presentation, but I would be happy if you understand the basic principles and if it is useful for your activities. So the first point is about the European data strategy. Let's begin with this part of the topic, the European data strategy and the data regulations. The European data strategy was launched in 2020. I'm showing a quote that comes from the European Commission, which says that the European data strategy aims to make the EU a leader in a data-driven society. Creating a single market for data will allow it to flow freely within the EU and across sectors for the benefit of businesses, researchers, and public administration. And as you see, it is a European priorities for a certain number of years between 2019 and 2024. It's a EU priority. As a reminder, we can say that the European data strategy is being developed while the global data volume is significantly increasing. Moreover, according to the projections of the European Commission for 2025, the value of the economy based on data should reach 829 billion euros in the European Union, compared to about 300 billion in 2018. The European data strategy is designed as one of the milestones of the European digital sovereignty. It is built in 3 stages. The first stage is the governance. The second stage is the creation of a single data market. And the third stage is data service. And each of these stages is subject to a legal instrument which is applicable in all the member states. That is why I was saying in my introduction that your colleagues, the colleagues you work with in the frame of partnership, international or European, are also concerned by this regulation. So 3 stage: governance, data market, and service. And in this session this morning, we will have a look on the governance part. Governance rules the access and reuse of data principally. So the data regulation. The European Data Strategy implements new regulations. The Data Governance Act is an important step of this strategy. It concerns access and reuse of public of data that are held by public sector, but that are protected by specific third-party rights. What we call third-party rights is when you hold, when you work for the public sector, when you hold data that you have obtained that are coming from another person, another organism, and that are given to you with a certain number of conditions, whether they are personal data conditions, whether these data are protected by intellectual property rights, for example. This data can be confidential, they can be protected by a certain number of secrets. This is what we call third-party rights, because generally you work, these configurations concern working with data that are coming from outside. So the Data Governance Act is a very important step of this of the European Data Strategy. And the second act is the Data Governance Act. The latest act is the Data Act, which is still under discussion, whereas the Data Governance Act has been approved and is to be implemented in September 2023, so this year, within a few months. The data regulation also follows the European Data Strategy also follows a certain number of pre-existing regulations that you may have already heard about. I mean, the Directive on Open Data and on reuse of public sector information that was issued in 2019. The Directive on Copyright and Related Rights in the Digital Single Market, also issued in 2019, and the very known General Data Protection Regulations issued in 2016, who concerned the protection of personal data. The data regulation, there are also, there are also other data regulations. I have written them as examples. If you work in environment sector or geographical sector, you may have heard about the INSPIRE directive, which establishes an infrastructure for spatial information in Europe to support community environmental policies and policies or activities which may have an impact on the environment. And there is also an oldest directive, which is a directive on public access to environmental information. But these are examples, and there are a lot of other examples of data regulations. The first group of data of regulations that I'm showing you is really the core generic group of regulations applying to data activities and to science activities in a generic, on a generic point of view. So let's now focus on science. The data regulations have a very large scope that can address various types of data, and research data are among them. So what do we put under the term of research data? Research data are defined as documents in digital form other than scientific publications, which are collected or produced during scientific research activities and used as evidence in the research process, or with the scientific community commonly accepted that they are necessary to validate research conclusions and research. This is the definition which is proposed by the European directive issued in 2019, which is a directive on open data and the reuse of public sector information. So you can see that the research data definition is in a regulations that mainly concerns the public sector. However, in the partnerships, we often work with the private sector, with public sector, with European or non-European. So this definition is a milestone for the partners to understand how research data is understood in Europe and how to deal with this kind of data, which you can see that it's a very broad scope. And for example, in France, we have a specific definition which complies with this definition, this European definition, which says that research data is composed of images, text, sounds, records, but the idea is the same in the French and in the European definition, is that research data is a milestone of a basic stone of the work of the scientists. So this is what to be remembered at this stage. Way to address how European data regulation impacts science is to follow the research data life cycle. It is interesting to see that public and private sector are concerned, since we have seen that the European data strategy is meant to be for the benefit of businesses and researchers and public administration. I'm now showing you a chart in which I tried to make a résumé of data regulations applicable to the stage of the different stages of data life cycle, which begins with the creation, to document the data, to analyze, to store, to share, and to preserve. So it's on the left part of this chart. And on the top of the chart, you can see the generic data regulations with the European regulation, Data Governance Act, Data Act, Open Data Directive. Then there is a place for specific data regulations, a copyright directive, GDPR, Inspire as an example. And the last box is about partnerships with the Horizon Europe projects. So you can see that all the box can be relevant. Each stage of the research activity can be relevant with the European regulations, and the partnerships are as they are organized by Horizon Europe. And as I was saying, the European data strategy is meant to be for the benefit of businesses, researchers, and public administration. I would like to say a word on the Data Governance Act, which will be applied in September. This the interest of this act is that its scope covers the data held by the public sector and that are subject to third parties' rights, intellectual property rights, confidentiality, industrial and commercial secrecy, personal data, and so on. This act aims at fostering availability and sharing of data. It aims at fostering trust between the producers and holders of data in public and private sectors. And this configuration can address situations such as public-private partnerships, which mobilize data at various scales. For example, in data-driven systems, such as research and development, research infrastructures, for example. So you may have a certain number of questions. I would be happy to discuss with you on the part I have just developed. But I can propose you focus on several questions, which are data property. What about IPR concerning data, research data? Is there something new in terms of text and data mining in databases? What about as open as possible and as close as necessary expression? And I would like to propose you a Horizon Europe checklist example for the management of data. So we can discuss now, or I can follow on my presentation as you prefer. So I follow.
Yeah, I think you
yes,
can.
okay.
You can follow us.
I go on. Okay. Thank you very much. So concerning data property, this is a question that is very often asked to legal services, and which sometimes is a source of concern in the scientific community. And the principle is that you can remind is that the general principle is that the data belongs to its producer. This is the basic principle. If you are an employee, then it belongs to your employer. And if you implement a doctoral research, for example, you have to check your doctoral contract or to see with your university or with the funding organism if your thesis, your thesis is funded by a company, for example, or by the public sector. This is the principle on property, but data is digital object. So it is very difficult to say that it's the same property as the property on a material object. So this is a principle that as legal counsels, we say to our colleagues who carry on research activities. But you must know that, of course, concerning authorship, concerning moral or immaterial creations, you keep the authorship of your work. Of course, but the management is the task of your employer, the management of data. And to manage the data is as owning the data. So the principle is that the data belongs to its producer, and you have to check the partnerships, the contracts, if you obtain the data through a partnership, for example. And the following question is, what about IPR, intellectual property rights? Concerning research data and intellectual property, in France and maybe in other countries, we use a certain number of terms in the definition of research data, which is documents, text, images, recording. And this description can lead to think that these data are covered by intellectual property rights. And I would like to remind you that intellectual property includes all the rules applicable to intellectual or immaterial creations. Intellectual property makes it possible to protect works, to mark an anteriority on their production, a sort of traceability of the work, and to reserve the use for the benefit of one or more people. But it is still necessary that essential conditions are met, which are originality or novelty. And research data, when it's defined as it is defined by the European regulation or by the French regulation, which complies with the European regulations, well, it's difficult to say the data is protected because you will have to, as a researcher or anyone, but you will have to prove that the data is original or creates a novelty which can be applied in an industrial process. So I wouldn't say that raw data, for example, can be protected by intellectual property. They are not systematically protected, as well as images or recording that are produced by machines. It's not, you can't see the creativity of the producer generally. It's really difficult to prove. However, research results, which include such data, can be more easily protected by intellectual property rights, since they are a global, a research result is a global object which has been obtained through data management, which is a sort of new object. And in this case, intellectual property rights are tools for organizing the transfer of knowledge or technologies between the partners. But data, research data as such is not, it's difficult to say that research data are protected systematically by IPR. We should more base the reflection on the research result. The next point is about text and data mining in databases. I talked about the copyright directive a few minutes ago, and this directive allows an exception to the intellectual property rights on database owners. That is to say, when you go and search third parties' databases, the copyright directive is creating an exception which only applies for scientific research purposes. That is to say, the regulation authorizes researchers to make data and text mining in databases without the authorization of the database owner. This text is applied in a certain number of state members, and it is submitted to a certain number of conditions. It's not very easy for a partner or a company which is not very, which has not the knowledge of scientific regulations. It's not easy for the companies to understand or accept that you can, that their databases can be mined in this way without their authorizations. So it is a new exception, and I really invite you to see with your legal support in what extent extent you can use these exceptions, because it's very new and it's a great opportunity for research, but it's very new for the global ecosystem of research, especially in the private sector. And the next point concerns the expressions, the European expression, which is as open as possible and as close as necessary concerning the opening of data. It's an expression which means that the public data, where this concerns the public sector data, can be open if and only if the third-party rights are preserved. So it is not an opening without conditions. But I know you will have, or you already have, a course of open science, so I will not develop this point here. But it's something to keep in mind, is that open data is an opening movement toward a society, but it also respects third-party rights, the rights of your partner, the right provided by the partnership contracts, for example. The next point is Horizon Europe, a checklist example. It is in French, but I can translate. It is issued from a session that I gave last year in Horizon Europe for teaching. And it shows you how, according to the grant agreement and according to the DESCA, which is the consortium agreement of European projects, it shows the step you have to check while entering a new European project. So this can concern data, softwares, databases. What you have to check is to identify the data. I'm on the left column. Identify data, identify how, if you can, how they are going to be used later, how they are going to be implemented with other data later, before, during, after the project. You must keep in mind that data can be given to other partners. So is it possible? Do you agree with this perspective or not? In which condition, etc. Of course, the data management plan is an important tool to use, and it helps to understand how the DESCA, how the consortium agreement will be negotiated among the partners. So there is an example on the left column of checklist that you can use, which is who is the owner of the data? Is your organism the sole owner, or did you obtain the data with partners? Or do they agree with using them in a European project? Another point to check is the data you are going to use in the European project are submitted to prior conditions fixed by third parties or not? Is there IPR on your data or software of databases? Are there confidential information? Are you using the FAIR principle, findable, accessible, interoperable, and reusable? And have you written a data management plan? So all these questions are here to anticipate the implementation of the project and to facilitate the opening or dissemination modality at the end of the project. So this is in French, but I will translate it if you're interested in this checklist. This next point is a question that research can ask sometimes they ask, but the project I am working in, is it concerned by open science? And in European Union, yes, when your project is funded by your European funds, yes, it is concerned by open science. Another question is, what are the obligations? What is compulsory in Horizon Europe? Well, you have to respect the FAIR principles. You have to respect the dissemination of publications conditions, and especially open access. And you have to be ready to give access to the data which you used to write your articles. But I don't develop, since you have a course on open science. The next question is about the data management plan, which is not only an inventory, technical inventory of research data, it also an important checklist too of the life cycle of the research data, from its ownership to its dissemination modalities and sharing. So this is the end of my presentation. I thank you very much for your attention, and I am open to a discussion if you have any question. Thank you very much.
Thank you, Stéphanie. I have a question for you.
Okay.
I mean, we work in this European project, and we have 6 universities in 5 countries. And I think, for example, in a project, in a research project that involve, if, for example, Italy, France, and Spain, which law we have to, the researchers have to consider, which law, how can I say, overruled. We have to consider Italian law or French law, even if the, for example, intellectual laws about intellectual property are different, or we have to consider European law in this case.
If your project is funded by Horizon Europe, the choice of the law is already provided by the contract, by the agreement, especially the consortium agreement and also the grant agreement, which is the Belgian law, which is very similar to French law, but it's something that is very it's a very it's a usage of it. It's very used. It's very common for the implementation of Horizon Europe or Horizon 2020 projects. So insofar as you are you live in a European country that is submitted to European regulations, the rules are the same. And the Belgian law was chosen because the Commission and the European institutions are in Brussels. So it's a compromise that has been found. If you are not funded by Horizon Europe or public European money, then the choice of the law is a part of the negotiation of your contract, of your partnership. And then generally it is the leader the scientific leader of the project, which imposed, between comma, imposed the law of his country. But this is part of the negotiation.
Okay, thank you.
Thank you for the question.
So I have another question for you, Stéphanie.
Yeah.
We talk about databases, and I found a few weeks ago in a framework of the PhD and plan de data management plan corrections, that there are some databases we have to pay for access. In this case, when the researcher has to pay for some databases, are the rules are different in this case?
When you pay the access to a database, it means that somewhere there is a contract, there is an agreement which establishes the rules of what you get as a counterpart of your payment, and you have to be very. You really must check what is provided by the database owner, what it authorizes you to do.
Okay.
See, I understand it is. It can seem very difficult to read a contract. It's often very long. There is a lot of pages. It's not. It's a very legal terms that are used, but it's really. You can see it as a memo, as a tool of what you can do and what you can't do. And when you pay, you also have rights to do some things with the database. And so I would invite you really to see what is provided by the contract, by the agreement.
Okay. Thank you.
Thank you.
Are there any other questions? I don't think so. This means that you were very clear, Stéphanie. Thank you.
Thank you. It's very complex. I understand it is it's a fascinating subject, but it tends to be very, very complex, and there's a lot of regulations that are coming. But once these regulations are adopted, it will be simpler. I hope it will be a bit more simple to understand. But we are just in the movement now.
Yeah, we are creating the
Yes.
participate in the movement. Yeah, it's very complex, and also in the same domain, in the same subject. Each research project is different.
Yes,
even if
absolutely.
we are in the same subject. So, but thank you very much.
Thank you very much too.